Rights and resources, hashtag HowiGotCustody. Want to do a video talking about doing background checks. The first thing that I do when I have somebody come to me and let's say you're a dad, your baby's mom lives with a guy who seems violent or gets hostile with you during visitation exchanges or, threatens you or whatever. Whoop. Sorry about that. The first thing that I do is do a background check on that person. There's so many people who've come to me or come to my office and they'll say, yeah, I'm really worried about my baby's mom's new boyfriend. He seems kind of like a hothead. What's his background? Does he have a criminal record? I don't know. Why the hell would you not check the background of somebody who, why would you not check the background on somebody who lives with your kid? You check, sorry about that. You check if you hire a nanny to watch your kids. Do you do a background check on them? Of course you do. If you're a manager at any kind of, any kind of business and you're hiring somebody, do you background checks on them? Of course you do. If you're an apartment manager, you do background checks on tenants. We do background checks for all kinds of stuff. But then when it comes to our kids, suddenly my gender goes brain dead and doesn't think it's necessary to look and see if your baby's mom's boyfriend's a pedophile or a sex offender or a drug dealer or has a history of violence. I had one time I had somebody come to my office. Well, I work from home now, but when I had an office, somebody came to my office and said, I'm really worried about my baby's mom's boyfriend. And I asked, what's the background? I don't know. You didn't do a background check? No. Do you have a lawyer? Yeah. The lawyer didn't look into it. In Washington State, if you're in Washington, you can go to Washington courts, courts.wa.gov, and you could do something similar in a lot of other states. You go to the Washington courts website, and when you see the website, you go to the upper right, there's a tab that says search cases. And then you could search by name, or if you already know the case number, you can do that. You put somebody's name in, as long as it's not Bill Smith or a real common name, you'll get all the court cases that person has in district court, in small claims court, in superior court, and if they've gone to the Court of Appeals. You could look up my name and you could see probably about 4 different James Christiansons in the state. But then if you know my middle initial or you know the area I live in and all the cases are in that area, then obviously that's me. Here's a free resource for you to find something that you can use against the other side, and you're not even thinking and using the common sense, obvious, legal 101, elementary, ABC, 1, 2, 3. You're fighting the other side. You're trying to find out which home is better. That person might have a criminal record. I should go look for that. Now, maybe they don't. But why don't you at least look for it? Somebody asked what website. That was Washington Court's website if you have a Washington State case. But if you go to White Pages or some other places and then, you look for somebody's address or look up their name, and then it'll give you the button to be able to go to People Finder, or I use Intellius when I'm looking for addresses. Sometimes it shows a criminal record. It's not that thorough, but most states have a search engine where you can look at the court cases for that particular state. I had a guy come to my office. He said he's worried about his baby's mom, and I was starting to say, asked him, or the baby's mom's boyfriend. The dude had an attorney, and an attorney didn't look at him. Attorneys in Washington have access to the database of Judicial Information System, the JIS system, and that shows all kinds of cases that don't even end up with a conviction. You could see more in there, and the attorney doesn't even look at it because the attorneys are lazy, because they don't care about your case, because they don't give a crap about you or your kids. You have to give a crap about your kids. This is why I tell people to represent themselves. I have people who call me and been watching my videos, and they're like, "Do you think I can represent myself?" And then I ask them, "Do you know my story?" "Yeah, you got custody without an attorney." Why the hell would you ask me if I think you can represent yourself when that's the entire purpose of my page? My gender is so ballless when they're talking to somebody who won something, and I was a warehouse worker who flunked out of college, so I'm just like you. Talking to somebody who's just like you, who won something, and asking, "Do you think I could do it?" You guys need so much affirmation, and you need a daddy in your life so bad that you'll ask me over and over, say, "Well, I can't really do it because I don't know the law." Before you drove a car, did you say, "I can't take driver's ed because I don't know how to drive"? Before you bounced a basketball, did you say, "I can't play basketball, I don't know how to dribble a ball"? What the hell do you do with anything else in life that you don't know how to do? You learn how to do it, then you go do it. My gender is so freaking cowardly that you'll make up an excuse to not want to do something on your own and give yourself the best chance to fight. Now, let's get back to background checks. A guy that I talked to today, he was in an eastern state. He was kind of almost Midwest. You know, that whole like Indiana, Ohio, Kentucky, Tennessee area. He was down in that little pipeline of area states. He had the same thing. Baby's mom's boyfriend is hostile toward him, has a hot temper, and this lady actually lost custody of two of her other kids. So we have multiple things here that should be looked into. And anybody with half a brain who can just think and do basic fundamental math and knows basic English should be able to figure this out. But see, you guys are so lazy sometimes, you don't think hard. If you look at the law in this guy's state, and this is similar to most states, and Washington's different, I'm going to tell you what's beneficial about Washington when it comes to doing background checks. In this state, it says that the courts must consider the history of the parents, the parenting abilities and all that stuff, drugs and alcohol, mental health of the parents, and whether there's been domestic violence. Now, it doesn't say you automatically get custody if the other person has domestic violence, but what it does say is the court has to consider domestic violence and whether somebody's gotten treatment or whether they've gotten better or whether they have a problem. Just by that, you don't need to be a legal scholar. All you need to do is have at least gone to 8th grade or middle school. You read it and then you think for a second, what does that really mean? What are the ramifications of that? How does that help me? This is what most dads don't do because they're a bunch of lazy biatches and they don't care enough about their kids to think hard, put energy toward what they're doing, and to read stuff carefully. And when you read the law, you should read every single word. When the law says the court shall consider, you can tell the judge, like, as the law says, Your Honor, you have to consider this. You could tell them nicely because the law says they have to do it. It's not an option. And a lot of you guys are not even attempting to put stuff in court and tell the court what they need to do, even though the law says they have to do it. You're afraid to tell them what the law says they have to do. That's insane. You are your own worst enemy sometimes. Now, in the case where the law says, hey, domestic violence needs to be a consideration, that obviously means that we want to protect children from a violent home, right? The court has to consider domestic violence or child abuse. That must be to protect children from a violent, toxic home. So, even if it doesn't say, now and we need to look into the stepdad or the new boyfriend, even if it doesn't say that, if it just says the parents, you could go to court and say, Your Honor, the state has a strong policy of protecting children from violence. The mom's new boyfriend that lives with them has a history of domestic violence. He has a restraining order from a previous girlfriend, or he has a domestic violence incident. Or I looked into it, and there's 2 different police reports of the mother calling the cops on this guy. We need to rescue the children out of there. That's a great argument. You see? You see how when you have some common sense and you put a little effort toward it and you actually exert some testosterone and you act like a guy with balls, you start making up great arguments in court? That's an argument that I rarely see anybody use. And your attorney says, well, They're not going to care what the mother's choices are. Let's just talk about your parenting. Now, in a case like that, let's say that there's domestic violence between, so there's different types of background checks you want to look into. And I know this hurts somebody's feelings because you got to put effort into fighting for your kid and you want to pay an attorney to magically make it go away. But it's time to grow up and be a big boy if you care about your kids. So if you're in Washington state and there's some other states, you do your research in your own state. How do I look up court cases online or plug somebody's name in? And there's a database that shows me their court cases. Or you might have to go down to the courthouse and they might have the Judicial Information Network at a courthouse. You can ask around. But if you're in a custody battle over which home is better for the kids, one of the first things you should do after you say, okay, this parent isn't fit, they're mentally ill, they're crazy, or they're violent. Who else lives there? The boyfriend or the stepdad and his other kids. And there's a teenager there who's touching my kid, and we need to look and see if they have a juvenile record that we can use against them. That's common sense. This is plain common sense, and it's left the family court because my gender is a bunch of ballless PABs. Punk, A for your gluteus maximus, B for the word for female dog. Lazy, shiftless PABs. This is a tool that people are not using. When somebody else lives with your kids, that's not just the mom. You should be attacking the mom too for her parenting deficiencies. You can always just look, like in Washington, you could click the search cases and you look up their name, and if it says Seattle Municipal Court and Walla Walla County Superior Court and this district court, then you call those courthouses. You have to use your fingers and type in on Google Walla Walla District Court, and you call them and say, hey, I got case number 4972447. Can you tell me the nature of the case or the charges and what the result was? Oh, that was an open container or DUI, or that was a parking ticket, or that was, selling heroin or whatever. And you make a note of that, and then you just share it with the court. You don't even got to go to the courthouse to go get that stuff. The internet access to find that case and a phone call to the clerk just gave you a huge weapon or some ammo to use in court. Now, in Washington state, it says if you live with somebody, if you commit domestic violence or the threat of harm, or even inflict the fear on somebody that you're going to harm them, if the court finds that you did that, they have to put restrictions on your parenting. So if you're violent, the other parent gets custody. So if a mom is violent, the dad gets custody. And then there's another section that says if you live with somebody who commits violence, then that parent who lives with the person, even if the parent didn't do anything, if that person has a violent history, we have to put restrictions on that parent, which is no overnights, can't have the child at that home or stay the night, or you have to have visitation in a public place, or you go to a supervisor facility because you invited a violent person into your home. But the vast majority of people who have situations like this are not even attempting to argue them, and they also don't even look into the background of the person that they're fighting in court. This is insane. I shouldn't even have to be doing a video on this. You should automatically want to know the background of every person that's babysitting your kid and that's spending the night at the house and that lives there. And if you don't know where that is, then you do discovery, where you're allowed to find that out by sending interrogatories. But I would never do just interrogatories. I would do a deposition and get the answers in person on the spot. See, when you watch my videos and you put stuff together, you're able to put these things together and have an overall strategy. But some people watch my videos and they're like, oh, he didn't get to the point in the first 10 seconds, so I'm turning that off. Or they watch my videos and they're not able to put it together. So instead of spending a few bucks to call me and get a consult with me, they just give up and they go back to their attorney who they keep losing with, instead of calling me and getting me to help them light a fire under their attorney. Or like a guy in Washington recently, he just went through a modification that he had 50-50 and they were trying to take it away from him and reduce it to every other weekend. Can't remember if they temporarily did it. But the mother was trying to take stuff away, accusing him of being abusive. They went to trial. A guardian ad litem recommended custody of the mother, and he destroyed all of them in depositions, and he destroyed all of them at trial. And then after he won his trial, the judge made some mistakes in his order. He did a reconsideration to set up an appeal, and the judge granted his entire reconsideration, which actually surprised me. I haven't seen that thorough of a reconsideration victory. I've won some reconsiderations, but usually as part of this and part of that, you almost never get the whole thing. He got the whole thing, and the judge even corrected some errors that he found on his own. So this guy exercised every single thing I'm talking about, and he had at least 5 or 7 consultations with me. He had an initial one, and he had multiple 30-minute consultations when he had a follow-up question, and he did a whole bunch of stuff on his own because he had the balls and he cared enough about his kids to take the information I gave with him, and he ran with it. And then when he was stuck or didn't know an option, then I gave him some other stuff. And then he was actually starting to teach me some stuff that I didn't know and share some case law with me. That's what I want to happen here. But it's never going to happen for 99% of you. And it's so frustrating because I have the information, I'm sharing it with you. It's accessible if you want it for free, if you want to spend out every waking hour looking for this stuff. But if you want a shortcut, you watch my videos. If you want an even faster shortcut, you get a consult with me. But guys don't want to do that because it costs $100 for the initial consultation at this point in time. I charge $80 an hour. Initial consultation has to be an hour and a half. There's no way that you just have a quickie question. I have people who call me, I just got a quickie question. And then they ask me another question. They ask me another question. I'm like, dude, you said a quickie question. We're 12 minutes in. I don't have time for this right now. What's your question? Oh, I just have one more question. Dude, you can't, do you want an appointment? Well, I can't afford one now. Bye. Don't call me ever again because you're trying to milk me and steal my time. You don't give a shit about your kids. You think this is a big magical fairyland thing. When you call James, you'll get a magical answer. Or when you pay an attorney, it'll all go away. You don't have the balls to fight for your kid. I already know the signs of stuff, okay? I'm sitting here giving you guys information for newbies and for people who wake up and say, I'm sick and tired of being a PAB. I'm sick and tired of not fighting for my kids. I'm sick and tired of my attorney losing. It's time for me to change. And only 1% of you will do that. But I'm here for the 1%. While 99% of guys are a bunch of PABs and won't fight for their kids, and they form groups and they get on Facebook and they spend hours and hours blogging about how the system sucks, nobody's doing anything about it except me. I'm trying to help people win one case at a time. And actually, I've gone to the courthouse and protested and helped change some things and gotten judges and commissioners to start changing their rulings. And of course, I've helped dads get 50-50 and full custody without an attorney. And guys are like, well, do you think I can do it? I have zero time for PABs. Once I see a sign you're a PAB, then that's it. You want to fight, people call me up and we have great conversations. I don't even raise my voice unless they're sitting there arguing with me why they can't do it. Then I got to tell them to wake up because their life with their kids is online. But for the most part, guys are afraid to call me, but women aren't. Women call me up and they say, I like how you talk. You're right to the point. I could see your passion and you actually care. And then we talk and I never hurt their feelings. And sometimes I have to be gentle and firm and let them know the truth. Let's get back to the background stuff. So you do a general check and look at all the court cases that they might have. Now, it might be hit and miss. You have a court case, all it is a speeding ticket. You see another court case in district court or in superior court or whatever. That might be a felony. I had a guy who came to my office. I don't think I finished that point. He didn't know what the baby's mom's new boyfriend, what his history was. And I looked him up and found a type 1 case in Washington. There's a code in the numbering system, and most states probably have something like that. When you have a case number, like if the case is 2022-1 and there's a bunch of numbers, that means it was the year to 2022, and type 1 is a felony in Washington, type 2 is civil, type 3 is family law, type 6 is mental illness. And then if it goes -0001, then that was the first case, that was the first felony filed in 2022. So there's meaning behind numbers, but that's for the Washington folks out there. But in Washington, it's mandatory. If you find somebody has any history of violence, they have to put restrictions on that parent. And that's a basis for you to get custody. Why the hell would your attorney not even attempt to look in that? This is how insane these attorneys are. And then you don't even think to tell your attorney, hey, let's check the background of this guy. Now I have every once in a while I have people who already did that and they call me up because they've been doing their due diligence and they use some common sense and they figured out I better get a background check. This guy seems a little scary. So you do a general background check and then you go look for all the court cases they have and go research them. Then here's another thing. The guy that I was talking to earlier today and many other guys, baby's mom has uh, a custody case or a restraining order case against a previous baby's dad. If she has a restraining order case against a previous baby's dad, and then this other guy is acting crazy and violent, she's inviting all kinds of violent people into her home. That's a problem. Or if that person still comes around because they got a kid together, you should rescue your kid from that situation. It's another piece of ammunition to use. I had a case in which here's my client and here's his baby's mom. Okay. The baby's mom had a new boyfriend that was living with her. So over here, she has somebody living with her. That guy that's living with her was a felon. Now, he had an arson case, but he wasn't allowed to have a gun. And there's pictures of him with a bunch of weapons on Instagram. So the dad used that. Also, we did a background check on that guy. His previous wife or girlfriend got a 5-year protection order against him. And so we went looking into that file. So if you find a case, a divorce case or a restraining order case, don't just say restraining order case because it might have got thrown out. Go look at the actual orders and look at the actual affidavits or declarations from the alleged victims. If there's a divorce case, look at the petition. Look at any sworn document, any declaration in court orders. Like if there's 300 documents in the file, just look for petition and declaration and orders. It's usually only one-tenth of the documents in there. If you have a sworn statement from somebody, your baby's mom. So this dude's baby's mom had a boyfriend who had a previous girlfriend. And so she had a 5-year restraining order against the dude. So there was a finding by the court of domestic violence. So this guy should be getting custody from her because her boyfriend had a finding of domestic violence in another case. And all I had to do was in Washington, all I had to do was look up the guy's name. His name was unique enough. And then I found a felony in Oklahoma, the felony with the arson in Oklahoma. So then we go and look up in his restraining order case. We go and look at the document. I can't remember if I did it or he went down and got it. I looked at the document. I said, go to the courthouse and get this, this, and this. This chick wrote a statement saying he would have a gun under his pillow and she was scared to even get up and go to the bathroom. He punched her while she was pregnant. He punched and broke the jaw of a previous girlfriend. So this is a sworn statement from another girlfriend from the previous girlfriend or wife that he beat up another girl. All kind of stuff that he can use against her in court. All reasons to get custody under arson. And if you guys can look it up, if you could just test me. Google RCW 26.09.191. And then look in section 2A and 2B. It says if a parent committed domestic violence, child abuse, or anything like that, the court shall put restrictions on that parent. And then in 2B, it says if they live with somebody who's harmed a child, molested a child, committed a sex offense, or even inflicted the fear of harm, just threatened somebody, waved a gun and said, I'll kill you, mother effer. That's a basis to get custody of your kid. And you guys aren't even looking for this stuff. That's what's so freaking insane about this. I mean, when I was ignorant and didn't know everything I know now, like I knew my baby's mom didn't have a record and she wasn't living with the new man. But as soon as I started volunteering for Dads America or Dads Against Discrimination, the Washington chapter, it was called Dads of Washington. There's a subset of dadsamerica.org. The website's still up, but all those guys are dead and gone or quit or burned out. One guy is waiting for the aliens to come to his rooftop because these guys lost their minds. When I was volunteering for Dads America or Dads of Washington, I would get calls and I'd volunteer on the phone. There was a few different people who answered calls, and they would bring up something like this. I'd say, well, why don't you do a background check? It was common sense to me, even though in my own case, I didn't see that or have that. It was just common sense. How do people not know this? You are your own worst enemy. You're your child's own enemy because you're the only person that can rescue the child from the crazy baby mom and her new crazy boyfriend. And you won't even attempt to even put some effort and get off of your lazy ass and go rescue your kid. And this is why I risk not being popular. You know, if I was like Judge Anthony and I was all nice and sweet and told you all my expertise and then I got a degree in, you know, law and justice and just bragged about my wins and talked nice, I'd probably have 5 to 10 times more followers. But I'm not going to BS and shuck and jive and fake you guys because I hear horror stories from people who spend $750 on Judge Anthony and all he does is talk about narcissist this, narcissist that. This is how you bow down and worship a judge, and this is how you go through the motions. Because he was a judge, he was part of the system. You don't see him out protesting the system, do you? No, he was part of it. There's one lady who's a lawyer. She has a page called Command the Courtroom. You guys should check that out. I'm not afraid of competition or other people who do stuff, but she doesn't. She doesn't. She says a lot of stuff that's true. I've only seen a couple videos. I've seen her interview somebody about dealing with a narcissist. Good stuff, but she's not shucking and jiving and faking and being a hustler. So I can appreciate somebody like that, but I don't think she gets harsh enough into the hardball. This is a war of attrition. This is where people get worn down and they fight until the other side gives in usually. And usually the mother is fighting and beats the father down and gets him to surrender. And attorneys intentionally, if you watch the movie Divorce Corp, C-O-R-P, Gloria Allred, who's a famous feminist attorney, she represented the prostitutes who sued Tiger Woods and said they were victims of his John solicitation of their prostitution, which is insane. That's like somebody at a Kroger grocery store or Walmart saying, we're a victim of this person coming and buying all these groceries. I think that lawsuit got dismissed. But anyway, Gloria Allred said, part of the strategy is just to paper the other side to death. If you go on YouTube and you type in Divorce Corp, C-O-R-P, and if any of you had some damn common sense, like some of you do, most of you don't, you would have already looked on my flow page and seen the link to the 2-minute video on Divorce Corp. That's very helpful. It's free. Got a bunch of free links. Just I got $50,000 worth of free videos, content on my YouTube channel. On my flow page, I give you a link to certain things that every dad should know. And there's a section that says must see information on my flow page. My flow page is linked. Let me just be clear. Under every video is a link to my flow page, which is like a link tree. It has all my links in one spot. I have a video under the section on my YouTube channel. There's different sections, most popular videos, corrupt attorneys and judges, James's resources. I have a video where I show you how to walk through my flow page once you get there. All my contact information, you can see my winning orders. And there's a section that says must see information. And I say must see because every dad must see that information that's in there. And one of the must sees is a 2-minute video that's an excerpt or a trailer from the movie Divorce Corp. It's the best documentary that's been done on the family court system. It came out like 14 years ago. All these other guys were getting sexually aroused because now the system is coming to an end. And it's still just as bad as it was because we have some PABs, kitty cat, gluteus maximus, female dogs that never do anything about it. Everybody's waiting for somebody else to come and rescue them from the system. But that if you type in Divorce Corp on YouTube, well, if you go to my flow page and you click the link, that's the video where it talks about false claims of abuse and abuse of protection orders. And you can go right in there and just quote the Harvard law professor and the 2 attorneys and the celebrity judge that's in there and the investigators in there and make an argument why the mother should not get a protection order against you. This is another abuse of the system. And I have a whole packet to defend against that. But you could also type in the word divorce corp. It's CORP as in Patrick for corporation. It's a play on the word. Instead of divorce court, it's divorce corp because it's a corporation and it's a big moneymaker. They have like 5 or 6 trailers that are only 2 minutes long. You don't have got to watch the whole movie. And there's one that says death by paperwork. There's one that says death by paperwork. And that one, Gloria Allred said that you just paper the other side to death until they can't take it anymore and they surrender. There's more proof right there by a famous attorney of how the court system works. You don't have to just believe me that it's a war of attrition. So if you don't get on the offensive and you bomb the other side, you don't have to abuse the system, but you use every resource that's available to help yourself win and to also get on the offensive, then you're not letting them abuse the system against you. So back to the background checks. You look for a general criminal check or any court case on your baby's mom if you didn't know her that well, or somebody that she lives with, a new stepdad or new boyfriend. Maybe her parents live there. And I had a case where the mom, was in her 20s and the grandpa had a history of gangbanging. That's a basis for that dad to get custody. Then if the baby's mom has other civil cases like civil restraining orders or a custody battle, go in there and look at the orders. They might find that she was mentally ill. There might be a guardian line report. There might be a statement from somebody saying they saw her throw a tire iron at the baby's dad's head, the other baby's dad. Or the dad petitioned for something, or the mother petitioned for something, and then he's like, he was abusive in the home and stabbed me, and that was a time when he was living with your baby's mom, and you put 2 and 2 together and say she's inviting these violent people in the home, and there's an occurrence of violence under her care. She doesn't have good judgment as a parent, and one of the factors in the law is good judgment, and looking out for the welfare of the kids and providing a home and environment. That's where you look at the factors in the law. So if you know the factors in the law and you know somebody's background and history, then you take their background and history and use it against them in light of the factors in the law that the court has to consider. Your Honor, you have to consider the parents' judgment when it comes to the parenting judgment and decision making and their mental health. Nobody in their right mind would be inviting violent people in the home when you got children like this. She's not in her right mind. You need to do a mental health evaluation on her. I want the kids to have a relationship with their mother, but she needs to get better and get healthy and well. And she's not. And she has another violent guy living with her. We need to rescue the kids. You have a strong public policy against violent homes, or a strong public policy in favor of protecting children and making sure they're in non-violent homes. Let's rescue the child from the violent home and the mother's bad decision making and her obvious mental illness and get her some help. So you put all this stuff together, and most of you guys are like, I don't have any argument. I don't know what to say. You didn't even look for shit. You didn't even attempt to look for shit. Back to the point, like, I'm going to call it what it is, because if you could win, if you got off your ass and did something, and you're not getting off of your ass and doing something, then I'll say, for your child's sake and your own sanity and the safety of your child, get off your ass and do something. Most of you out here, I should do a video this entire, most of you presume that you're doing everything on your case. You're not doing jack shit on your case right now. I could count probably on 2 hands, maybe 20 people out of 20,000 cases, and they came to me and they've done everything they could on their case that I could even think of. Over 20, since doing this, well, really since 2001, 23 years of doing this, I've seen about 10 to 20 people who did everything that they could. You're not doing jack shit. I just talked to a guy at the end of the call. I said, you're not even attempting to fight, and you got trial coming up. He goes, I did attempt to fight. What did you attempt to do? Your attorney didn't even attempt to go for custody. Your attorney didn't talk bad about the mother in court. Your attorney didn't do discovery. You didn't even attempt to do the basic stuff. You think that you attempted to fight for your kids because you had a court hearing. If I have a boxing match and I don't train for it, and I show up in the boxing match and I keep my hands down and I let Mike Tyson knock me out, and I'll say, well, I tried to fight really hard, just because you showed up, you showing up is not good enough. You have to be in it for the long haul and the long term, the long marathon of a war that family court is in. And you have to go all out from beginning to end, just like any other war. Don't be a stupid jackass and think that you've done everything because you exerted effort. If you don't have custody or 50-50, then you probably did not do everything that you can do in court. And this is why I'm trying to wake dads the hell up, because you're living in a delusion. You know, we talk about women being delusional and unaccountable, and in the dating world, they're in denial and they want all this stuff from dads and they want to extract resources from dads and destroy them. And then they'll go to court and lie and say there's a victim and there's no accountability. And they lie to themselves. That's what dads do when they go to family court. Well, I'm trying. Well, I'm doing everything. Did you do this? No. You didn't even use 5 weapons right off the top. Discovery, motion. If you lose a motion, you do reconsideration and all your optional recourses for that. You get on the offensive. If you're like 90% of the cases out there, the mother tried to get a protection order against you. Did you cite all the, and quote, all the lawyers and judges out there who say women lie about protection orders all the time? No. You didn't even attempt to do anything. And you're whining and crying that you got your ass kicked and you didn't lift a finger. Now, if you're fighting hard and you're doing everything you can, and or you got a consult with me and you're watching my videos, this doesn't apply to you, so you shouldn't be offended. Those of you who are offended, you're mad because you spent money on an attorney, and you're mad because I'm sitting here talking and telling you to wake your ass up, and it hurts your feelings because now you know you didn't do everything that you could. And you could have found out. There's a guy who said, man, on the comments, I wish I would have known about James 10 years ago. You could have known about me if you got off your ass and you weren't so satisfied with your attorney getting your ass handed to you. There's so many people out there, they're letting their attorney settle on something that they don't want. They're letting their attorney go to court and half-ass it and not say what they told them to say, and you tolerate it. That's your fault. When attorney after attorney and person after person was telling me, I can't get 50-50, I can't do this and that, I didn't stop. I didn't let people deter me. I didn't let people tell me, you can't do this and you can't do that. I said, my daughter needs a father and I need to be equally involved, and I should have my daughter every day because I work at night and the mother works during the day. And attorneys even told me I'll get every other weekend. I said, you must be out of your freaking mind, because I'm not a pussy ass bitch who sits there and accepts stuff, stupid ass stuff that people tell me, because it was insane to me that somebody told me I can't be equally involved. I don't care if the entire world believes that. I don't care if all the judges are for that. You know, all the judges in America at one point were for slavery. They were for Jim Crow laws. If we had Jim Crow laws right now, we would think that's insane. If we said women should be at home barefoot and pregnant, and we should have laws that women can't work, that would seem insane. But there was periods of time when that was acceptable. I'm one of those people who, in the time when something insane is acceptable, I don't accept it because I have some balls. It's time for men out there to grow some balls. And all I'm talking right now is about clicking a mouse and putting a couple words in the computer, or driving down to a courthouse and looking at a file. Is it really that hard? This is the obstacles that guys refuse to, hoops they refuse to jump through. And most of you say, oh, I'll die for my kids. But you won't drive to the courthouse and go look at a file and read a couple things for half an hour or an hour to find out if the mom's boyfriend is a registered sex offender or a child molester. Or if he was accused in his divorce of touching his kids, your punk ass would say, oh, there's no criminal finding. Your dumbass didn't get off your ass or use half a brain to realize that you got a restraining order against you. Was there a criminal conviction of domestic violence? No. Well, how did that happen? Let's start using our brain, fellas. How did that happen? Because you're in civil court, and civil court can do stuff even if there's not a criminal conviction. So if they could do that to you, follow along, boys and girls. If they can do that to you, and baby's mom's new boyfriend, his ex-wife said he touched the kids and stuff, they can make a finding in this court that they're concerned about him touching kids because it's civil court, and they don't have to wait on a conviction. If they could do that to you, you can turn it around, do the same thing. You know, I didn't know anything about discovery in my family court case. My baby's mom's attorney sent me a questionnaire with 147 or 70, about 160 questions. And what did I do? Did I sit here and just act like a little bitch and just answer all the questions and give it back and obey them and bow down and not do the same thing? No. They threw a spear at me. I turned around and threw it at them. I got on Microsoft Word and on my crappy computer and I typed up a Word document that looked exactly like theirs, and it took me hours and hours. And now I have templates and packets, and I actually give you guys a free link to interrogatories. And the vast majority of you don't even use the free link or buy my $45 packet. If you do interrogatories and you spend $45 on one of my packets and you take some time to come up with some of your questions, that's a guaranteed $500 to $1,000 the mother has to spend on her attorney to answer those questions. And most of you aren't even attempting to do it. But even more powerful is a deposition. And I have a couple videos talking about depositions, how it's the number one tool weapon. And the vast majority of you have never even thought of, or never even cared to, or you even saw my videos and you don't want to use the number one weapon. If you're in a war and the other side is shooting bows and arrows, and you got a bazooka, or you got grenades, or you got a rifle, you would use a superior weapon to the other side to help fight and defeat them. Yet in family court, you see James's video talking about a deposition. Well, that seems kind of hard and that seems kind of difficult. Then be a pussy ass bitch and quit on your kids and just make it easier for yourself. If you're not going to use the weapons of warfare in the war over your kids and act like a man with balls and actually do this stuff, then make it easier on yourself and just quit. And then you don't have to exert any energy. You can just lay down and watch Thursday night football, Saturday college football, Sunday NFL football, Monday night football, and you could just enjoy life and not give a shit about your kids. But why go to court and put a half-ass effort that's an automatic loss? Why not gather up, do background checks, gather up as soon as I started attacking the mother at my first court hearing, I could see her wilt because she was looking at me and laughing at me walking into court thinking she's got me because she got an emergency restraining order. But I went in there and fought, and the judge said, you guys go to family court, get a parenting plan, and come back the next week in a couple weeks. We come back in a couple weeks. Did you get a parenting plan? No. But I do have a hearing a couple weeks from now. I didn't get a parent. It takes a little while, Your Honor. He goes, well, okay, you guys go to family court. I'm a criminal judge. I don't know anything about family court. It looks like there's no danger here. So I'll keep the temporary anti-harassment order in place until you go to family court and it falls off. Don't come back to my court again. So we had 2 hearings that lasted about an hour each. And in those hearings, I thoroughly embarrassed and exposed the mother because I got on the warpath from the beginning. A lot of you guys will sit there and say, well, I'm just kind of waiting. I don't know why she won't reason with me or work this out. This is dragging out and wearing me down. Why isn't she worn down? Because she has control of the kids and child support and alimony, and she's punking you like a little bitch. How can you be a punk little bitch and you're getting destroyed in court and you're still hoping and waiting on her coming to her senses? Or that you got some kind of leverage. You never went for full custody. You never called the mother out for being a child abuser. Any parent who doesn't want you to have 50-50 is a child abuser because they're depriving the children of the basic life need of a father. And they need fathers in the home full time. You can't have father's structure and father's protection half the time, and the kids are vulnerable and open to child molesters, and the mother's Disneyland mom home half the time. That messes a kid up. But you don't want to rescue your kids because it's too hard or it looks politically incorrect. I'm worried what the judge will think. What does the law say? Oh, I don't know. I didn't look at the law. So you're going to a court of law with an attorney at law to fight for your lawful rights, and you don't know what the law is? What the F is wrong with you? If I'm taking driver's ed or I want to learn how to drive, I have to read the driver's manual. I have to take driver's ed classes, and I have to drive a car. I don't ride a bicycle and watch the Jurassic Park series and hope I learn how to get a car. This is how stupid you guys are. You want to do all these side things. Well, I'll just sit back and wait for her to get her act together. She's destroying you. She's got control of you and the kids. She has no reason to work with you. The first day that think about, okay, everything that your mother's doing, think about what would you do with the total stranger? The mother allows your kids around a sex offender boyfriend. Would you let your kids stay the night with a sex offender? Would you let your kids stay the night at their friend's house if their dad was a sex offender? Hell no. But you'll do it if it's your baby's mom. Baby's mom gets a pass on criminal abuse of children. If, I mean, you wouldn't let the kid stay the night if the dad was drunk and yelling at his wife. That goes on at your baby's mom's house with her new boyfriend, and you tolerate that. You're just hoping that the guardian lion will figure it out on her own. Some of you guys are saying, some of you guys. I had to tell a guy today, stop talking about what you told the attorney of yours or you told the guardian lion. I'm asking him, what did you do about the mother's violations in court? Well, I told my attorney. Okay, what was done about it? If somebody breaks into your house, do you tell the neighbor, hey, somebody broke into my house? I can't believe why they did this. It's really horrible. It really kind of sucks that they did this. And they break into your house again and like, man, I don't understand it. Why would somebody do that? It's such a horrible world that we live in. You're sitting there talking to your neighbor and hoping that it goes away. The way that it goes away is you call the police and they arrest the person to put them in jail to stop them from doing it. I told this guy these exact words. Every time I asked you a question, what did you do about it? You said, well, I told the lawyer, I told the guardian lion, I told my mommy, I told my daddy, I told my uncle, I told my dog's groomer. I mean, he didn't say all that. I'm exaggerating a little bit, but he kept saying, I told my attorney, or I said this. I said, what did you do? D-O. I want people to do stuff. You guys love to yak and talk about hot air bullshit. Well, I told the guardian litem and they did. The guardian litem is not on your side. Why haven't you figured that out, you moron? You are the answer to your kids getting rescued. You fighting are the only one who will fight for your kids. You are the only one who gives a shit about your kids. The mom took the kids from you and destroyed the father-child relationship. She wants to move halfway across the country. She wants to let a knuckleheaded boyfriend live with them. She wants the kids to go to daycare and school 5 days a week, but you only get every other weekend or 1 weekend a month. What kind of insanity is that? Why are you not looking at this for what it is? Because you've been a henpecked little simp little bitch and she's been punking you and you're letting the Jezebel spell still be cast over you even though you don't live with her. And some guys actually tell me, well, I still love her. Okay. Well, she doesn't give a shit about you and you don't want to wake up to reality. Let your kids be ushered into a world of toxicity, narcissistic control, and be abused by the next boyfriend that comes running through. And it's your fault if you don't try and fight. Now, if you try and fight and do everything you can, you get screwed, which sometimes happens, then that's the system that we're in. And just like I admit all the time, I'm a stupid jackass for having a kid with a crazy woman. And I'm actually a stupid jackass twice within 2 decades. I played Captain Save-A-Ho with a chick who I thought was a victim. She put on a great act. I got played by her. Fortunately, we didn't have any kids or anything like that. But, I still got played and I saw, it's kind of a lesson because now I see how stupid my gender could be because I was stupid and we believe the best and we see all the signs. I had a good, dating relationships with women in between the 20-year period that, my psycho baby's mom and this Jezebel 304 that I dated. Outside of that, I had a nice track record and there's people who still well, there's women that I date. There's a woman I dated. She still, my daughter goes and visits her. She lives in another state now. My daughter goes and visits her. And, other women I dated, there's one woman I dated that I probably could have married her. She would have been a good wife. And then I just had so much going on and being a single parent. If we had little fights, I just didn't want anything to do with that. And after we dated, we actually used to babysit each other's daughters when we'd go on dates. So I've had cool relationships with people that I've dated before. But I've been a dumbass and I can own it. I've had several guys who said, life just threw me a curveball or it just wasn't in the cards or it kind of sucked. I had a kid. I wasn't planning on having kids or I wanted to wait and I had a kid. No, you had sex with somebody. And if you have sex with somebody, you could have a kid. If you didn't want to have kids, that was unplanned and stuff. It wasn't, you got dealt the wrong cards. You made a stupid, dumbass mother effing decision, mother effer. Stop acting like these modern women and being in denial of your own accountability. Just because sex is rampant like never before. And kids who were, when I was in middle school, it was a score if you French kissed a girl on the first date. Now it's a score if you're 13 years old and you run a train on a hoe. That's the culture we live in today. And we think it's normalized to have casual sex. You're a dumbass if you have casual sex and then you're mad that you had a kid out of casual sex. You must be a freaking retard. Let's have some freaking accountability. And then when you have a kid and you want to be a father, then just own it. Say, I was stupid. I had a kid with a crazy chick. Now I got to go to war over my kid. And I did that with my baby's mom. I would have rather, and you guys need to get out of this utter, pathetic, simpish BS. Well, I'm just waiting on her to get her senses together. I just wish that why can't she be so? Dude, she's not a man. Men think logically, women think emotionally. Women will look at you and say, I don't like you right now. So I'll do stuff like take your kid from you. I'll lie about you. And it's okay because of the way I feel about you. You propose 50-50 with your baby's mom. Then you go to she says, F you, that's crazy. Then you go to mediation, and the mediator might miraculously, this has happened before. The mediator might say, this is a great case for 50-50. You guys live close together. And she goes, oh, okay, that makes sense. And then you go, oh my God, I offered that to her and she said no. Why did she say yes to the mediator? Because she doesn't hate the mediator. Women don't listen to logic in what somebody says. They're looking at the person. They're relational. Do I like this person? This mediator has a power suit and tie. He has all these law books on the wall. This is how women get bamboozled going to a used car dealership. This is how Eve got bamboozled. They get bamboozled by slick talk. Okay? They're not going to think logically about the case. You have to beat it into them through the court system and get them found in contempt and get them in trouble and get them held accountable and go to court and say, I could care less whether I talk to this woman ever again. I just want to be an involved father. She's sitting there saying, I want to be with her and I'm harassing her. The only time I even talk to her is if or when I need to find out if my kid is okay. That's exactly what I told the restraining order judge when we first went to court. We were in a criminal court and she's trying to get her son. I said, Your Honor, wait a minute. They're talking to you like I'm calling her house to get at her or I want to talk to her. I could care less whether I talk to her ever again. I just want to be an involved father. So I'm calling to check on my kid. They're sitting there saying, oh, well, James called the house. Her roommates are there testifying on her behalf. Your Honor, I'm calling the house because my kid's there. I would never call this woman ever again. I had to make up my mind. My daughter is more important than the mother. Now, I'll never tell somebody to get a divorce because that's a covenant between you and God. I will not touch that. But once the divorce process gets going, or once you have a court case with a baby's mom and you weren't married, you may never be that husband again or the boyfriend again, but you will always be that child's father. So why don't you go and secure the father-child relationship? And if she wants to work it out or reconcile, then she'll come along with it when you get custody. But a lot of guys are out there, I'm just waiting for my baby's mom to reconcile and I want to reconcile. And if you go to court and say, I was only calling because I want to reconcile with her, and you think you're winning angel points with the court, she's saying she doesn't want anything to do with you. And you're sitting there saying, well, I'm a good guy. I want to reconcile. And, she really doesn't mean this stuff. You're in court talking to her. You need to get out of yourself. You're in court talking to a total stranger trying to get your guys' story down. And she's saying you're a monster. You're saying, I want to be with her. You look like a psycho stalker, you dumbass. You're sabotaging your own case. Go rescue your kid and secure a kid. You will be that kid's parent forever. The fact that she's such a Judas that she betrayed you and she's willing to take your kid and use the kid as a weapon against you. She's a child abuser. Why would you negotiate with a child abuser? Same case scenario. Would you let your kids stay the night at somebody's house or go to a camp when they got abused there? Then why would you let the mother abuse your kids? Or if a teacher verbally abused your kids, would you pull them out of the class and complain about the teacher? Of course you would. But you won't do it with the baby's mom because you don't want to hurt her feelings because you're a simp little bitch. I don't want to talk bad about the mother. Why not? She's a child abuser. 60% of physical abusers are the mothers. And I guarantee at least 80 to 90% of the alienators' psychological abuse is done by the mothers because they're the ones getting control. And I guarantee 80% of the child molesters are the new man the women let into the house. There's a guy who said there's a 400% increase, 4 times the odds, automatically. The greatest predictor of child abuse is if there's a step parent. Because men just don't abuse their own kids. Men are protectors. Now, some men do, but 60% of women are the physical abusers. And then you got uncles and aunts and cousins and all that stuff. And then so the dad is in the minority because we're the protectors. Women are not protectors like we are. We were designed to be protectors, just like an alpha male in a lion pride. And even knuckleheaded dads will protect their kids just because they got an ego and this is mine and my property. If anything else, they'll do it for that. But most dads do it because they love their kids. We get sickened to our stomach at the thought of a child being harmed. You're the superhero in your kid's life. You're the only person that can rescue the kids, and you're waiting on a radical feminist, man-hating lesbian who got molested by her dad, hairy-legged, psychotic butch lady who could never get a man. You're waiting on her to write a report in your favor? And even if they do, the court doesn't have to listen to it. What the hell are we doing? You have to go to war in your court case. And you have to use every weapon available. And I talk about all kinds of weapons: depositions, reconsideration if you lose. If you lose in front of a commissioner, California and Washington have commissioners. Other states have magistrates or friends of the court. What's another word for it? Magistrate, friend of the court. Something else. I filed bar complaints against every attorney and guardian litem. I sued some guardian litems in small claims court. I sued these people who testified that I shouldn't be around my kid. I dropped those suits because Judge Joe Brown and Judge Judy called me up, and not them, but their assistants. Those guys are always looking. They have people in the field looking at every single small claims court case, and when they see something that's really dramatic, they call people up and say, "You want to come on our show?" But the other side has to agree, and they didn't agree. And just dealing with I basically got my point across. And those people have never bothered me again. That guardian litem didn't want to come on board. My baby's mom's first attorney, when we went back to court, he didn't want to come on board. I beat the snot out of these people, so they're afraid to even deal with me. That's how the game is played. Now, I didn't violently beat them up, but I used every recourse available, and I was not afraid to expose them or call them out, like 99% of dads are afraid to. See, everything you see on TV and everything you see in a father's rights group is utter bullshit. You see on TV all the time, or on even Pearl when she's interviewing people. They're like, well, the dad's leaving. And Pearl focuses on, well, you picked a bad dad. You picked a deadbeat to have kids with. Now, she's starting to, she's doing some research about, women using restraining orders. And she did an interview with me that she took down. I don't know why, but she did. It was a nice little interview. And some people found it educational, but, and she said she learned some stuff from my interview. I wish I would have downloaded it and saved it. I was a dummy for not doing that, but I didn't think she would delete it. But, I guess she kind of covers it, but there's so many other people, red pill people, who are sitting here saying dads aren't the monsters that people make them out to be, but they'll still say these women are picking bad men to have kids with. No, that's not it. The women are the bad people abusing the court system to push the men out to get welfare and child support and alimony and control the kids or vindictive vendetta. Nobody's talking about that. Everybody out there is full of shit, and you guys don't like me calling a spade. You know that's true. What I just said, you all know that's true. And then you get mad at me because I talk about other truths, like you're being a coward and being a bitch and you're not standing up and fighting. You don't like that one. You like it when I say, hey, the system and these women, and if I project blame on them. You like that truth that nobody's talking about except me. But then when I turn around and say, grow some balls and be a man, you don't like that. That hurts your feelings, because you got to put some effort to it. Or you got to admit that you're wrong. Or you got to admit all the effort that you put into it was, you did all this work and energy for nothing. And you don't want to admit that. And you got nothing as a result. A lot of the most richest people in the world, they don't all work 80 hours a week. Some of them work smart, and they talk about working smart and making decisions and delegating to the right people and doing the right things and learning from their mistakes. Or they read books by like Warren Buffett or somebody else who talks about money mistakes they made, and they avoid those pitfalls. I tell you guys mistakes that I make when I do one-on-one consults. I wouldn't do that. I would do this. And I save you hours days, weeks, and even months of anguish in making a mistake in a pitfall. But the vast majority, you don't want to get a console and learn that stuff because it's not worth $100. But you just spent $100,000 on an attorney to get destroyed in court. This whole thing is backwards and insane, and you guys don't like it when I call a spade a spade. You're your own worst enemy. And you know what's crazy? Some of my biggest haters are men who got offended at me calling a spade a spade. Guys who lost in court and say, you just got lucky. Your baby's mom is black and she's a crack whore. I have a hater on TikTok who said, you just got lucky because your baby's mom is black and she's a crackhead. My baby's mom is a human resource manager who doesn't drink or do drugs at all. What's your next allegation? Oh, you just won because you're a white man and she's black. No, I live in one of the most liberal states in the country. They will bend over backwards for women, and particularly women of color. What next? See, my haters are so delusional because you lost and you didn't listen to me the first time, or you just found me and you can't believe you put so much energy in there and lost. But most of the stuff that I talk about, you could have figured out on your own if you really wanted to, or you could have searched the internet and found me anytime in the past 14 years. So all your excuses are out the window. And you don't got to beat yourself over the head. Just stop living in a delusion and a lie and saying it's somebody else, it's the system. It is the system. But what are you going to do about it? Are you going to not see your kids because the system is bad? If somebody kidnaps your kid, here's another total stranger thing. A kidnapper kidnaps your kid. Are you going to sit here and wait and hope that the police find the kid? Or are you going to go looking high and low for the kid? 100% of you will say, I'm going to go look along with the police until I find my kid. But when your baby's mom kidnaps the kid, you just sit around and just wait for somebody else to do it for you and rescue the kid. See, when we act like men in regular everyday life, once we go to family court and the mother gets control or they're fighting us, we turn into total PABs, little punks, as biatches. And we don't do the common sense, like this, the main point of this video. We don't do background checks, an easy way to access information to use against the other side if somebody has something wrong with them. Even if you don't have, the baby's mom isn't living with somebody. She might have a baby's dad from a previous custody battle. I would look through every affidavit in that to see if the baby's dad says, well, she's mentally ill. When I saw her taking get strung out of Oxycontin or something like that. You got a testimony from that guy who saw it firsthand. And that's assumed on his face to be a sworn statement that he really believes that and he really saw that until somebody proves it otherwise. Let me get to, I think I got a couple comments. Speak truth, I'm from the same generation you are. I already filed a judicial complaint. I filed judicial complaints against my judge, and the Commission on Judicial Conduct did not do anything. And I announced on the record that I filed judicial complaints. Now, I didn't do the judicial complaints just to set it up so I could say this, but I'm like, you know that I filed a judicial complaint against you. And then he said, well, I didn't know that. Well, now you know. So now you're biased against me. Oh, I could be objective. And I actually sued him in federal court. He said I could still be objective. Then my baby's mom, her attorney, showed him a picture of my previous website, and I had a picture of him and his wife and his home address and his birthday, and then a big old story of what a corrupt subhuman piece of shit he was. He said I could still be objective. That's impossible. So the problem with doing a motion, complaint on a judge and a motion to dismiss it. Now, some judges have dismissed themselves because of complaints. So I'm not saying it's impossible. I'm just saying I didn't have much luck with that. But I got the judge reversed in the Court of Appeals, and then I went and told everybody at the courthouse and embarrassed him. I protested his house and told everybody what a racist he was, what a child abuser was, what a child trafficker he was, and that he loves a racist attorney, my baby's mom's attorney, who called an Asian attorney a lying C word for Asians. And so I used everything and bombed the crap, and I made everybody's life miserable. That wasn't my goal, but by getting on the offensive and growing some balls and actually fighting, That made them miserable. That's why the first guardian ad litem didn't come back on. And so I had an easier guardian ad litem to deal with the second time around. First guardian ad litem was a mess to deal with. I still kicked her ass, but she was harder to deal with. The first attorney didn't want to come on board. And then he wrote a declaration saying I was the toughest case he dealt with, which is a compliment. So that bitch, Mark B. Livis from Kirkland, Washington, what a piece of work. So, I guess I got my point across. And I don't understand, like, I've had people come in and out. You would think that people come in and out. There's a couple people ask questions. You would think people would come in and out of here, would actually seize the moment to ask a question to get some free information from me, but people don't even do that. It's amazing what my gender doesn't do. Let's see, the judge and attorney at my last hearing didn't even hear me out. They just wanted to go straight to trial without hearing out the case first. I thought that was weird. Now we have a trial hearing set. What type of hearing did you have? The judge and attorney at my last hearing didn't even hear me out. You say they didn't hear you out. Does that mean you spoke and they ignored you? Or they cut you off and you didn't get to talk? And what type of hearing was it? If it wasn't a hearing where you had a motion for custody or anything like that, and they didn't change the order, then there's nothing to do. Or if it was a status hearing, you guys just go there and casually talk. If you're saying they didn't agree and settle, they don't have to settle with you. Most dads out there, you should want to go to trial, and you should want to use trial as a leverage. And basically, the setup of trial, 95% of court cases settle out of court. And when you guys are racing close to trial, at some point, one person backs out and says, please, let's not go to trial. Let's not go to trial. I'll take you to trial and I'll go for please, what will it take to settle? See, if you take it all the way to trial, they might just be bluffing and they don't want to go to trial at all. Mom used my 16-year-old daughter to make a declaration of abuse, and now she's using her as a witness. Okay, I've dealt with cases like that. So she's sitting there manipulating the child and abusing the child and using the child as a weapon and putting the child in the middle of it. And there's probably some conduct of the mother along the way that could be used to say, look, the mother acted like, or let me have the kid before, and then all of a sudden I'm abuse her afterward. Or I have cases where the mother's accusing the dad of abuse or being a molester, or they're concerned about danger, and they said the danger happened a while ago or several months ago, and they've been giving the kid to him even without a court order. Their actions show, you should find something in her actions that shows she doesn't even believe her own allegations, so you can't believe her. And you should have all kinds of evidence of alienation and women coaching children, and that it's prevalent in court, and it's more likely than not that that's what she's doing. Attorney did mention, whose attorney? Which attorney? Your attorney, the opposing attorney? I assume that mentioned settling at the last hearing after he's seen the binder I had. Okay, so there you go. That's the type of stuff that I'm talking about. You go to court, you're not effing around, and they don't know that until you actually show them your trial notebook, your witness list. And when are you going to trial? If you're going to trial down the road, you should do a deposition on her and grill the crap out of her and catch her in lies. So it looks like you're kind of on your way. And see, that's the type of stuff I'm talking about. So this guy, Dan, he has a big fat trial notebook, and the attorney was willing to settle with him and talk negotiations because he's like, oh my God, this guy is serious. So you're calling his bluff kind of. He may not want to go to trial. 95% of attorneys don't want to go to trial. And even the ones who do, they'd rather settle out of court. But if they have to, they will. What would you do when judge ignores mother's domestic violence against the father in a relationship? First of all, I would be announcing on the record that domestic violence is a danger. And there's some states like Washington State, they don't have to follow our laws, but they can use it as influence. Some states will honor somebody else's law or case law and consider that. Because sometimes in the factors in the law in your state, it'll say the court has to consider these factors and these factors or any other factor that's relevant. Well, here's this woman that committed. Now, it depends. Does the judge believe she did it and doesn't care? Or does the judge not believe she did it? It's two other totally different approaches. If she believes she did it, then how come you don't want to protect the child from somebody who has a violent? Usually domestic violence is rooted and grounded in some mental illness. So we have two problems right here. Why would you do? And that's where you tell them what their own policy is. Every single state has a strong public policy to protect children from violence. We have established that the mother committed violence. Why would you not want to rescue the child from violence? Why are you endangering the child by ordering the child to live with somebody who's violent? Or why are you not treating her violence? The only answer could be misandrous, sexist bigotry against one gender by this court to the detriment of the child. And then I would say this court system has a history of horrendous misconduct and bigotry and prejudice against women before rape shield laws, against Native Americans, against the Japanese when we used to intern them during World War II, against people of color, obviously, because there's been KKK grand wizards who are judges in the Jim Crow South. America's courts have a horrific history of maltreatment and mistreatment of certain groups of people. And now the newest and latest bigotry is bigotry against fathers. And while the entire society is crying out for fathers to step up to the plate and be involved, here I am willing and ready to be available. I have no history of violence, and the mother has history of violence. And you reward her with the child to the detriment of the child. You not only have an allegiance to the child, that's your number one allegiance. And I talk about this in my videos all the time. You guys should be picking these arguments up if you watch, or getting a consult with me to get this stuff. You have a duty of care to the welfare of the child. Do what's the very best of the child. What's best? A home with violence or a home without violence? A home with toxicity, a home without toxicity? A home with hatred and anger, or a home with peace and love? A home with mental illness or mental detachment, or a home without mental illness? See, I just piled up and painted a picture of how atrocious it looks to leave the child over there. And then you can even say, I want the child to have a good relationship with their mother, but the mother needs help, and the mother needs to get healthy. And your number one allegiance is to the welfare of the child, not just good enough to get by, not just enough so the child has a relationship with both parents, but the very best optimum. Is it the very best optimum interest of the child to be in a home with violence, with mental illness, with toxicity? No. It's in the very best optimum interest of the child to be in a home with love and peace. And then the court has a duty to society to not release this child into a bad situation which should end up dysfunctional and be a menace to society, or be a mental health case to the society. We got a mental health crisis, and it can be rooted and grounded in not having a father in the home. You have a chance to fix that and rescue the child and do your duty of care to the child and to society. Do it. I set it up as much as possible to make them look as stupid as possible and feel as stupid as possible in light of the law, the facts, the cultural norms of society. And I'll throw in stuff about the history of the court, because if you go in there and say something like, oh, the court's just being biased, that's not good enough. You have to tell them, it's not blasphemy for me to tell you that you're wrong, because there's a history, there's entire documentaries about how the criminal justice system abuses poor people and people of color, and it's well documented. So the courts have a history of injustice. My judge wrote a letter to the legal community saying we got to do better for black people during BLM riots and stuff like that. Now, he was full of shit. He was being politically correct, but he admits how the court system is corrupt. And if he admits the court system is corrupt in 2020, then it could be corrupt in any kind of way. So I would use their own words against them and their own history against them too. How do I request a deposition from the other side? You need to follow the rules of depositions. Every state has a rule of discovery. So if you're going to do a deposition yourself, sometimes in some states, it's just you send them a notice, you set up a deposition in a court reporter's office. If you have an attorney, they send a subpoena to set it up. If your state requires that you get a subpoena, you have to motion the court for a subpoena for the clerk to sign off, and then serve the mother. Depends on your rules of discovery. Look at this, whatever. If you're in New Mexico civil rules discovery, and read those rules. And, maybe the facilitator can give you a shortcut that I don't know of, or you can get a consult with me. You're in California. Okay, I've had people in California. They just they set up a deposition, and they sent notice of deposition to the mother, and they went to the deposition. She showed up with her attorney, and they grilled the crap out of her and destroyed her credibility. I've had a couple guys in California do that. Daycare refuses to give access or facility or records for minor child. I'm in Florida, but daycare is in Alabama. Judge says it's out of her jurisdiction to tell daycare to do anything. First of all, that's utter bullshit. If the kids are in that court, if your case is in front of Judge Williams in Florida or whatever, they have personal jurisdiction over the persons of the father, the mother, and the children. And it's not about the daycare as much as it is the mother should be sending records to you. But also, I talk to people about this all the time. I have a demand letter packet in my store. The daycare is not the owners of the children, or the schools are not the owners of the children. The doctors are not owners of the children. You're paying them for a service through your child support, or the mother is. If you know Troxel versus Granville, you have a right to the care and control of your kids. They're violating your constitutional right by hiding records of your kids. They're either a state entity or a private entity who's hiding records from your kids. And most states have laws that say you have full access to school and medical records unless there's a court order banning you from getting that. If the courts can order that you don't get access to school and medical records, they can order that the daycare hand that stuff over. But also, you can do discovery on the mother. Do discovery and demand her to hand over all those records. She must have records from the daycare. But also, I would write a demand letter to the daycare and say, I'm going to, hand over these records, or I will be suing you in federal court for $1 million. Actually, I would say, give me $1 million for not giving me records, or I'll see you in federal court for $10 million. And then I'll individually be suing each one of you in small claims, and file a small claims against one of those. This is what I would do: file small claims against one of those people and serve them, and do it for the maximum $10,000 or whatever, and then say, I'm going to go to federal court and sue you, and write a demand letter and talk about Troxel versus Granville, and see if there's any state bill of rights for kids, and then tell them that you don't have control of my kids. You don't get to dictate. You don't get to side with the mother. You're discriminating against me as a man and a non-custodial parent, and treating me like shit, just like you used to treat black people in Jim Crow South, and we're in the South right now. Now the new bigotry is against men. All kinds of stuff you can do and say with those people. And then go on to Google Maps and say, these people are discriminating against me as a father. They hate fathers. They're a bunch of radical feminist, man-hating cult women who hate fathers. All kinds of stuff you can do. Do I need a deposition from the other side before going to the temporary restraining order trial hearing? Even with all the clear and convincing evidence that I have. Have you ever questioned the mother and got her under oath and get her to contradict herself? You want every single thing that you can get. There's never enough evidence that you can get. If you have 10 witnesses, you don't say, well, I got one witness, I'm not going to use all 10. Use all 10. You're about to go to a trial. If you're going to question the mother on the stand, why wouldn't you want to know her answers before she gives the answers? A lot of people say, and a lot of attorneys say, and I have a video where I have 2 videos where I talk about depositions, and I cover most of these points. 3 videos. When attorneys say, let's not do a deposition, we don't want to tip them off. Once you ask the question and they answer it, you've locked them into the answer, and you know it now. You were in the dark about their answer. They can't change their answer, so them knowing your question is not an advantage because they gave the answer and they're locked in. You pulled something out of them, and they're going to say, oh, well, you tipped them off. They can't change their story. And in fact, you ask them a question, you get an answer. You can blindside them with another question to trap them. Like, do you think children need parents? Do you think parents are important? Do you think they're equally important? Do you think they should have equal time? Yes, 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 and no. Why shouldn't they have equal time with something that's equally important? Where do you get that from? And then you get them on the stand and say, so you don't have any scientific data or any research or anything that tells you that a mother is more important. You just think a mother is more important. And you could do follow-up questions because you already pinned her down in some questions in the deposition. That's why I say in my video on depositions, it's the #1 tool available. The judge allows the mother's grandparents to interfere. Video calls allows the mother to call directly. It tells me I need to call a separate phone via another subscription to have video calls. I'm not sure what you mean they interfere. If somebody interferes with your call time. That's contempt. Do a contempt motion. With my son's mom states she has separate phones. If you got separate phones and separate issues, if you're calling, you're supposed to be able to contact your kid and you're getting through, that's not a problem. If you, I don't understand why you're saying the judge is letting them interfere. The court order is the court order. If you're supposed to have phone contact, nobody can interfere with it. It's contempt. And if somebody's interfering in the mother's home or that the mother's around, the mother should be ordered to make sure that it's facilitated. And she's neglecting if she's letting somebody interfere. Now, text messages, pictures, we have been seeing each other through all the years. A lot of allegations are being dangerous or abusive. And we just have a baby who's now 5 months old. Okay, that's great. But what I was talking about with the deposition is you should ask her, what happened? What's dangerous? If she said, oh, well, he's dangerous, ask her to get specific. And if she can't get specific, then you know how to attack her in court and you know how to argue ahead of time. There is no, oh, I got enough evidence. You don't know what her statement's going to be at the hearing. You haven't pinned down every one of her testimonies and every one of her arguments. Pin her down so you know everything. If you know the playbook of an opposing team and the plays they're going to run, that's like, if you could find out and watch film and watch all the tendencies of opposing football team or basketball team or soccer team, they always pass the ball to this person when they go past the midfield, or they always run the ball to the right. If you watch film and you can know that, you can lean toward that way and prepare for that and stop it. If you say, no, we're in shape, we don't need to watch film, why would you not try and learn their tendencies and what they're going to do? So when you go to court, why would you not want to know what she's going to say to the court and be able to trap her and know it, prepare ahead of time? There's never enough evidence that could defeat the need for a deposition. A deposition is her own testimony out of her own mouth and her own story. And if you get her to contradict herself, she doesn't have credibility anymore. That's the whole purpose of going to court, is to destroy somebody's credibility. They come to court and say, you're a monster. You say, I'm not. And the court has to decide who they believe. If you destroy her credibility in a deposition, you win before you even get there, because you're going to show that to the court. And you're saying, why do I need a deposition? I got evidence. You're thinking in your own mind about your perspective of what's going on. You're going to talk to a total stranger who doesn't know or give a shit about you. You should want to go to court and do every bit of digging that you can and get every piece of answer that you can. And her testimony is evidence. If you can destroy her testimony, get her to contradict herself and say, well, I don't really have a reason. I'm just afraid that, well, what are you afraid of? I don't know. Boom, she doesn't know. So she can't go to court and tell, I don't know if he'll do something. She has to say, I know he will do something. Boom, you got her. Now, that's just an example. I don't know if she'll say that, but those are the reasons why you do a deposition. How do I file for temporary parenting plan and get full custody? The mother was convicted with DV in both criminal and civil. The judge still gives the mom majority visitation time. First of all, look at the law in your case. Well, you're asking me, how do you go to court and get full custody? You already went to court and you lost. So I don't know if you're going to try another motion or you're going to do a reconsideration. You need to look at the law. If the law says they have to consider domestic violence, and I kind of already gave the answer earlier. You go back and watch earlier in the video where I'm talking about the court has a duty of care to rescue a child from violence, whether it's the mother or father. If you're allowing a violent mother who has a criminal history to have custody and control of a kid, then you're saying violence is okay toward children if mothers do it. So if a mother stabs a kid or beats a kid down and cuts them to pieces, you're saying it's okay as long as his mother does it. Talk to them. Use their own reasoning and their own decision to make them look stupid. But I would need to know the details of your case. You're asking, how do I fight my case? You need a consultation for that. If you're not asking a very specific question about a very specific issue and you're saying, how do I fight? You need hours and hours of consultations, to be honest. But you need to start with the law. If you didn't argue the law and any mandatory things on domestic violence and the law, then that was your first problem. I don't know if you did or didn't, but that's where it starts, is with the law. You argue the law, and then you argue in a way that makes the judge look and feel stupid if he doesn't do anything. And then you go to the Court of Appeals if you have to. The guardian ad litem tried to get me held in contempt for protesting him, ordered to pay him and get a psych eval. The only reason the psych eval stuck was because the judge asked me one ethic question. Okay. That sounds stupid. I can call because we have one co-parenting app, which I facilitate calls to mother. But in order to get the calls, I need to buy a second subscription and phone. Judge won't order mother to. I don't know what to say about that. That's just the logistics of court. So I would tell the court, why are you creating a needless expense? We could just use the phone that they already have. Why do I have to do something extra? That's where, if you watch my videos, you'll see they need to make findings of facts before they conclude anything. What is your finding of fact as to why I need another phone? What is the reasonable cause that you're doing this? Because I'm going to harass the mother on the children's own phone? The mother shouldn't be hovering around them. If I call the mother, say, oh, that's good, the kids are going to spend time with their dad, and just ignore any call or keep her distance. There's an answer and an argument for everything. A lot of times, I can't give a cookie cutter argument that works for everybody in every case because your case is different. That's a kind of unique situation with the phone calls and the judge is ordering a separate thing. So that's something I only thought of right here on the spot when this guy poses this right here. TJ is talking about this particular situation. So a lot of times you guys, again, you need a consult for your particular case and your particular details. You can't watch my videos and then I talk about some legal principles and then that's the end all be all for every case. You have unique situations in your unique case that need unique one-on-one stuff. I mean, just like with counseling, you could go watch a counselor talk about, oh, when people have this problem, this is the therapy and this is the stuff that you need, or the self-esteem, building up your self-esteem and your confidence again. But you might have a particular situation that's different than the next guy because nobody is a cookie cutter robot, and there's specific customized things that people. Almost every phone call I have, we're talking about something I never talked to anybody else about because that particular situation was different. So the best specific deep answer you can get for strategy, if you're struggling or you're losing or whatever, is to get a one-on-one consult with me. Her attorney already gave me their exhibits and statements and declarations. Her attorney wanted my binder and my exhibits, but I did not hand them anything as of yet. Yeah, I wouldn't give them anything until the deadline. But if you're saying that you already got her declarations and that's why you're not doing a deposition, that's not what I'm talking about. Her declarations are limited to the content in the declaration. You want to go deeper in a deposition. So right now it sounds like you're not understanding the gravity and the tool and weaponry of a deposition. And you're sitting here arguing with me that, oh, I got a declaration from her. Her declaration is not interrogating her and asking questions. Why do you say this? And why do you say that? And you see, a declaration is on the surface allegations. You want to dig deeper. When you have a witness on the stand in a murder case, they'll say, where were you that night? I was at Burger King. And where were you sitting? Oh, I was in the corner over here by the play area. Well, the murder or the assault happened at the counter. And if you look at the picture of the Burger King, there's these pillars here. How did you see that? See, if we say, oh, I know what he's going to say because he wrote a statement saying I saw the assault. But then when I go to Burger King and I look at the structure of the facility and I know he was sitting there, I'm going to trap him on the stand because I've done investigating more than the surface statement. A deposition digs in, and it's like a mini trial. It's a practice run at trial. The separate phone is with the grandparents who really watch the child. How do you appeal not final judgment in Florida? An interlocutory decision. It's a whole monster on its own. We call it discretionary review, where if somebody makes such a crazy ruling, the Court of Appeals, you can only appeal at the end of a case. But if somebody makes such a crazy ruling that's outside of the scope and box of authority of the court, and they go outside of the norm and make such a crazy ruling as to question the integrity of the court, or they go outside the status quo, the Court of Appeals can intervene in the middle of an open case. I won a discretionary review, which is 10 times harder than appeal. I show you my winning discretionary review on my flow page, and then my reversal of a regular appeal. We call it discretionary review. It's interlocutory. Mom's allegations don't make sense because they're all from years ago while we were still being with each other. Okay, that's a great argument that you have. So, in other words, if I was so dangerous, why was she continuing to be in a relationship with me? Okay, so why don't you want to get her answer to that question in a deposition so you know what her answer is? So when you come and allege it, see, if you go to court and you say, this is a great example why you're not understanding the depth of a deposition. You're sitting there saying, my argument makes sense. Why was she with me if I was abusive? You know what the obvious answer to that is? Or she can have a million other answers. If you go to court and say, Your Honor, why was she with me if I'm so abusive? Then when they get the chance to rebut what you said, they'll say, oh, well, we all know that people who commit domestic violence have coercive control over a woman, and they control her, and they have a spell cast over her, and they keep her imprisoned in her mind, and they have narcissistic control. And boom, they win because you weren't ready. That's why if you ask her that question in a deposition, you will get her answer and lock her into her answer, and then you can attack her excuse for that. But right now, you don't know what her excuse is. You just asked the question to me right now, or you weren't asking me, but you were pointing out the obvious question. If I was so abusive, why did she stay in a relationship? There's a lot of women who stay in abusive relationships. And then they turn around and pin it on a guy and they win in court. You should do a deposition and grill the crap out of her. Why did you stay with me if I was abusive? And then she says, oh, well, coercive control, and you had me controlled and stuff. Okay, well, you had your sister over here and your brother over here. You could have moved in with them. Why didn't you just move with them? Oh, because you controlled me. So I really had all that control. You came and went often doing this, and you went on vacation with the kid or kids to Disneyland one year for a week. Did I control you then? And you get to pin her down even more. That's my answer on that. You should do a deposition. If you don't and you get caught off guard, then that's your fault. Now, you have a great case to win, but I would try and do everything that I could, including I would never, I never did a deposition. I didn't find out until deposition, until my case was over. And when I worked at a law firm, McKinley Irvin in Seattle, as a legal assistant, we would do depositions at the very beginning of a case as soon as it was filed, because we wanted to get answers right away. And most attorneys won't do that. So I know this from experience, from not doing it, the disadvantage of not doing it, and the advantage of doing it. Thanks for the reconsideration advice. Closing argument in a week. I got to consult with you before. Now, Florida, you want to look at. Florida's confusing, and even lawyers are confused about it. There's reconsideration, and there's a motion for a new trial. You need to figure out, if you're going to do reconsideration, which one applies. Because I'm still confused about it. Because attorneys are debating about which one do you use in which situation. And one of them delays the deadline on appeal. And another one, if you do one of them, it doesn't delay the deadline on appeal. So if you want to do appeal, let's say it's a motion for reconsideration. You do a motion for reconsideration, and the appeal is due in 30 days of the order. You still have to make that appeal deadline. But if you do a motion for a new trial, and you get a new trial or a new hearing, then 30 days is tolled or starts retolling or recounting after that new hearing. So you have to figure that out. I don't got time to jump into that. It's already confusing, going off of my memory. The judges won't care about that minutia, the phones. You're probably right, but I would still make a stink about it. Why are we making this complicated? We're talking about kids talking to their dad. The average normal human being says, hey, your dad's on the phone, here you go. I remember when I was a kid, my mom would say, hey, I'm talking to your grandma, and just give me the phone. That's a normal human reaction. Just because there's conflict and she hates me doesn't mean she needs to hate the child's need for a father. What's happening right now is she hates me more than she loves the kids. And then you go into court and say, so there's a balance of this. The judges may not care, but you should try and make them care. Your Honor, any reasonable person, there's an invisible person in every court called reason. Any reasonable person would say, hey, the dad's calling, it's your time with your dad. Here, let you freely love your dad and have time with your dad, because even though I hate your dad and how he was a bad lover, boyfriend, husband, cheater, whatever, I love you guys, and I love you so much that I'm going to give you access to your father. And yet we're making it complicated. We got to go through the grandparents and have a separate phone. Why? Because the mother's immature and mentally ill. Why do we have to cater to her mental illness? Why can't we do what normal, reasonable people do and force her to do that? Because she doesn't like it? Because she's a narcissist? I would make arguments like that. So there's an argument for everything. We have a letter cut off to send these messages. Can the judge order? We have a letter cut off to send these messages. Can the judge order me to produce a psych eval because of one question? Whether I felt it was more important to expose the ad litem's bias? Again, there's a bunch of angles to this. Judge, where's your finding of fact that there's a concern about my mental health because I opposed a guardian ad litem? There's countless stories about guardian ad litem corruption out there. The guardian ad litem was appointed by the government, by the state. So that's an agent of the state. And I'm redressing a grievance to the state, which is my constitutional right. And you're saying I'm mentally ill because I follow my constitutional right? There's case law, up into the state of Washington up here, there's case law. This is where you need to look up case law too. And I tell you guys, if you're not looking up the law and case law and knowing all the rules and using all the weapons available, the science, the data, and the code of judicial conduct for judges, the rules of professional conduct for attorneys, the guardian ad litem rules, you need to know all that stuff to be able to weaponize, to have all your weapons and arsenal ready for an argument. The guardian ad litem, especially if it's an attorney, has to follow the guardian ad litem rules and the rules of professional conduct. They're held to an extremely high ethical standard. This person isn't even doing the ethical standard of a clerk at McDonald's. This person is retaliating because they took it personally. They're supposed to be professional enough to set aside their emotions and just focus on the welfare of the child. They were assigned to do this and that in the court order, and they're stepping outside the bounds of it. And we're all opposing parties in this. I have a right to say my piece and make arguments in court. And because I'm making arguments against somebody who's an opposing party, basically, I have to get a mental health evaluation? You need to make a finding of fact that how you're concerned about my mental health because I oppose somebody who works in a profession that has a history of pathological lying and abuse. In Washington State, case law up here says, you not only have a right to oppose a guardian ad litem, you have an obligation to the court to point out what's wrong in their report. So Washington State, I have a guardian ad litem packet in my store that you guys never even order most of the time, except for a very few who actually want to look into my resources. There's a guardian ad litem packet in there where I make arguments against guardian ad litems. And again, in a different state, you can cite case law in your state and they have to follow it. If you cite case law in another state, they don't have to follow it, but they can use it as a guide. The case law that's in my packet that says guardian ad litems have been corrupt in Washington, so they created guardian ad litem rules and laws because they were acting rogue. There's a lawyer who became a judge who wrote an article in the Bar Association's journal, the Bar News up here, that said there was a growing concern that many guardian ad litems were getting out of control. You should Google and find articles about guardian ad litems being corrupt in your state. There was a guardian ad litem who ran for judge, and he got prosecuted for threatening to kill underage male boy prostitutes for sucking his stuff at his office. He solicited underage prostitutes near the courthouse when he was a guardian ad litem, and he got charged with threatening them and some other crime, and he was convicted. And then he appealed, and he won on appeal because of some technicality. But that's the corruption with the guardian ad litem industry. And I have videos on that stuff. And you should be pointing out some of the top parenting evaluators on guardian ad litems are sexually deviant perverts. And guardian ad litems have a horrific history in this court system of abusing power. The documentary Divorce Corp shows a guardian ad litem who was a promoter of cocaine, gay leather S&M bondage parties, and he was still a guardian ad litem. You should point out horror stories of guardian ad litems and say, I attacked the guardian ad litem on something they did and they retaliated and they're mad about that. This shouldn't be a tit for tat, middle school drama filled, you know, ranting case. We're sitting here arguing legal stuff, and you want me to pay $5,000 to prove I'm not mentally ill because I exercise my right to criticize the guardian ad litem? All kinds of arguments for that. One majority custody holiday time, 3 weeks out of 4, November and December. Shared in January. Hopefully I'll get my 50-50 back, unjustly taken. Well, in Florida, you got the presumption of 50-50 is in the best interest of the child, and they have to do that. I mean, that's great that you got the congrats on fighting and getting the 3 weeks out of 4. Florida legislature said it's in the best interest of the child, presumably, to have 50-50. Why are we not doing that? What is the specific finding? It's presumed it's best for a child to have 50-50. That means it's dangerous if we don't have it. So you need, and you should demand the court, you need to make a finding that there's something more dangerous about my 50-50 presence than the automatic danger of my absence, because the legislature recognizes it. All the science and data shows it, and you should be showing them the science and data on that. So if you're going to endanger the child and take 50-50 away, which harms the child, according to our legislature, you're supposed to do what's best for the child. And 50-50 is what's best for the child. And you're doing something different. That harms the child, according to the legislature and according to the science. You see how I take the stuff, that the law and the evidence that I have that's free on my flow page, and I slap it together like that? This is what you guys should be doing and learning. And if you're not doing it and learning it, you need a consult to learn how to do it. And so it's automatically dangerous to take away, to, let's say you guys are 60-40. It's automatically dangerous to do 60-40 or 80-20 or whatever you're doing. You need to make a finding of something that's dangerous about my 50-50 presence. Because it's undisputed, it's dangerous if we don't have 50-50. So you need to make a finding, you know, that greater than less than sign. You need to make a finding of something greater, that's a danger that's greater than the automatic danger over here of not having 50-50. So we have a dangerous parenting plan or visitation schedule right now. What's the finding that the risk that I pose by having 50-50? Why would you do that to the children if 50-50 is in the best interest of the child? You need to make a finding as to why. What is it? And demand that. I've been watching a 4-hour deposition of DCFS worker. Man, they're backwards. Yep. She wasn't leaving with me. She had already separated from me and was living with her parents. And she was still calling me to sleep with her parents knowing, which eventually they found out. Okay, do you have proof of that? Do you have her confessing to that? If you do a deposition, you can get her to confess to that if she hasn't confessed already. Another reason why a deposition is helpful. I definitely missed the opportunity for a deposition in my case. I'll get her next time. Definitely use case law, guys. You'll make attorneys look dumb. Right. Actually cited no case law whatsoever. Well, I had a half dozen. Cool. That's C. Robbins fly. I did that for my parental coordinators in New Mexico. Do you think it's a conflict of interest of a judge with the presiding judge, a mother's attorney? Oops. Do you think it's a conflict of interest if judge was the presiding judge of the mother's attorney's divorce? Yeah, especially if they ruled in their favor. Or if there's any appearance of bias or anything that could call into question the judge's objectivity, that they're biased and they need to recuse themselves automatically based on the mere appearance of bias, not even actual bias. You should find case law on that. Judge never disclosed this. Mom's attorney has insinuated a predetermined outcome. Put that in a motion to get the judge recused. Do you have a trial packet that can prepare me for trial? Yes. Or TRO trial. Temporary. If you're talking about temporary restraining order, I have a defense against protection order packet, and the main benefit of it is the structure of the declaration to defend it. I have Washington law on there. You need to take that out because the Washington law doesn't apply. But I have countless articles and quotes from several different people about how women lie about protection orders. in how they do it more often than not. So in a preponderance of evidence court, where it's more, the court has to go off of what's more likely than not. If the bar association and attorneys and judges are saying women do it more often than not, it's more likely than not that she's lying. So they should start with the presumption that she's lying until she proves otherwise. So my defense against protection order packet, there's all kinds of people who've gotten that and who've won. I'm not saying it's 100% surefire, but it's just another tool or weapon, and it's definitely worth way more than the $45 I sell it with. Like you could go and do your own research in Google and look for bar articles and quotes and stuff like that. The other thing is you need to know the evidence rules, because if they say, oh, that's hearsay what those people say, those are quotes from actual publications that are admissible in court, because magazine articles, newspaper articles are self-authenticating according to evidence rules. If you don't know how to use evidence rules, I have an evidence rule video, or you can get a one-on-one for that. If you have a trial packet, okay. I'm afraid my 16-year-old daughter statement of exaggerated claims will hold the most weight on the judge. It might. That's where you need to learn how to say, her claims are so over the top and exaggerated and histrionic that no one can really believe this. And she's coaching and using the child. And why are we letting a 16-year-old get in the middle of this? The fact the mother's manipulating a 16-year-old and using a 16-year-old and putting the child in the middle of it is disturbing. That goes to show how the mother will go to any lengths. And this is very common for women to lie. Or if you want to, just watch the Divorce Corp link. Google, go to YouTube and type in Divorce Corp and click on the false abuse claims and use that, how they lie about child abuse all the time. I have a misdemeanor DV conviction. The judge took 50-50 away when I had pending felony charges of false. Okay, wait. So you have a misdemeanor DV conviction? If you do, that could be used against you. But the judge took 50-50 away when I had pending felony charges of false allegations. She didn't allow me to present evidence, hence reconsideration motion. When I go to court, I don't wait for the judge to allow me to present evidence. When I file a brief or an argument or a motion, I attach all my evidence to that so it's on the file. And I give them a working copy. Now, if there's rules against that and you present it, then you got to make an argument why it's relevant. But I get my stuff on record and in the file, so they can't say, I'm not going to let that be filed. Case law states when you don't hear from both parents, I was found not guilty of 2 felony charges. Who pressed charges against you? If it was the baby's mom and you're found not guilty, then she has a history of the crime of false reporting. And if she's willing to commit a crime in false report stuff, she's definitely going to be willing to lie in family court and commit perjury. That's an argument that I would use. Another thing, if you're dangerous because you had a misdemeanor, look at how stupid this is. This is why you should demand a finding of what's the danger. Because if you have any overnights, if you have 50-50 taken away because you have domestic violence, why do you get any overnights unsupervised time? And why do you get all that vacation time? Are you all of a sudden you're dangerous during non-vacation times of the year, and when it's the holidays, all of a sudden you're cured of your domestic violence problem? See, you want to use the judge's own illogical bullcrap against them to make them look as stupid as possible. These people are full of crap, and we let them get away with saying stupid stuff without challenging it and saying, well, if you believe I'm a monster, how come I'm not a monster on Thursday, Friday, and Saturday when I get the kid? Is it just I'm a monster Sunday through Thursday? You don't even believe these allegations, Your Honor. The fact that I got a misdemeanor DV conviction or I copped a plea or whatever, if you copped a plea, I would say I copped an Alford plea. They added a bunch of false stuff on the record at the hearing. How do I remove it? You should have objected and said you got blindsided. You have a right to defend yourself. That's the fundamental fairness doctrine. You should have asked for more time to prepare to defend. This is why a deposition is good. You get all their answers. What are your concerns at a deposition? What are your concerns about the father and why? And they come up with something new at the hearing. We just did a deposition. They said all their concerns. Now this is brand new. They're lying, Your Honor. They're making up bull crap. They're slinging as much mud to the wall and hope some sticks. They're they're going with the I. You guys should watch my video, the 4 H's, talking about hot air, hysteria, hyperbole, histrionics. They just go to court and they throw a bunch of triggering buzzwords out there to hopefully trigger the court to make an emotional ruling. So utter bullcrap. But if somebody comes to court and says a bunch of new stuff, who said that? The attorney can't testify. This is where you need to know the evidence rules. You guys are asking a lot of questions. If you've been watching my videos, you're asking a lot of questions about basic fundamental stuff that you should know going to court. And if you didn't get a consult with me when you had a chance to, then you're selling yourself short and not learning all the information you can get. You can't half-ass this stuff. Now, some of you may have just found me after you had a hearing, after you got screwed. But you can't watch my videos and just take pieces and say, that's good enough. You need to know everything. You either need to study my videos thoroughly and do extra work and research, or get a consult and save yourself hundreds of hours of research and just get a consult with me. Everybody wants a shortcut or take the easy route or half-ass this stuff. And I'm not saying you guys are doing that, but this just led me to think some people, they'll watch my videos and they'll ask me, well, how do I get ready for trial? Well, if your trial's coming up, you should know how to do that by now. And if you've been watching my videos, you should have got help getting ready for trial because you're half-assing it. Your life with your kid is on the line. You should know everything that's available to you and every potential weapon. So I don't know if I fully answered this. I represented myself. Oh, yeah. So they added a bunch of false stuff on the record. So if the attorney added a bunch of false stuff on the record, then the attorney's testifying. If the mother added it and she got to testify, you should be able to confront your accusers. You have a fundamental fairness doctrine right to be notified of the allegations against you and the proceeding and to be able to respond and prepare. If you were blindsided at the hearing, that violated your fundamental fairness doctrine right. So your constitutional right was violated. So you should have a reconsideration or a new hearing on that. Okay, looks like I'm caught up to the questions. I'll just leave it at that. So all you guys that are really fighting, keep up the good fight and hang in there.